Clearly, staff in the Department of Justice have been working hard over the last while, and we're seeing the product of their work in a number of bills being brought forward this fall session, including class proceedings, wills, and this bill, Bill 22, the Family Law Statutes Amendment Act 2010. This is an important act, and it's an important act because it helps to legislate and regulate the most intimate relationships in our life. That is, those relationships of family, of parents to children, of spouses to each other. And I spent an awful lot of time on this bill when it was first brought forward and indeed passed in 2003. And that was the sort of huge reshaping of all of the Family Law Act in Alberta was pulled together under this new Family Law Act. And in fact, I spent one very, very long afternoon on November 27th, 2003, as we worked our way through the government amendments to, and they had a lot of them. I can't even remember how many, but it was dozens and dozens, government amendments to their own act, and then my sub-amendments to the government amendments. Because the situation that I was trying to address then is even more relevant today. And that is a situation when we look at families and who's in families today. We have a couple of different combinations and permutations. So we can have married homosexual couples, we can have common law heterosexual couples, we can have married homosexual couples, and we can have common law homosexual couples. And we can have single people with children or single people without children. And what's happening in the first section of Bill 22, the Family Law Statutes Amendment Act, is there are some adjustments being made, but they do not capture all of the categories that should be captured. And I suspect that we are going to see this bill back in front of us again, because if we continue on with this, it remains charter challengeable. You cannot make distinctions between essentially the same groups of people or people that are performing the same functions. And that's what we have here. And the courts have been very clear in the way that is being set out. And yet this government's personal philosophy, and I don't doubt anyone here would deny it, there's a squeamishness there about addressing this issue head on, and they won't do it. So once again, for example, we talk about best interests of the child, which was a very good philosophy to apply in this case, and very helpful to the courts and anyone else that was making these decisions. But in the government's view of the interpretation of best interests of the child does not include that child being in a same-sex parental household. So they don't include that under the definition of best interests of the child, and they must, and they should. Certainly, let me back up. Those amendments that I was bringing forward on that November 27th afternoon in 2003 were all about trying to make sure that we were not assigning a gender to the roles that were involved under this family law statutes. And yet the government insists on doing that. They insist on using genderized language like mother, father, rather than parent, or what's the other definition that shows up in here all the time? Husband and wife instead of spouse. Because, as I said, we have legalized same-sex marriage here. What do? You don't have a mother, or you don't have a husband and a wife in those situations. You could have a husband and a husband, or a wife and a wife. But you don't have what my honourable colleagues on the other side feel more comfortable with, which is that traditional heterosexual marriage. So what is being anticipated here, and what you're fixing a little bit of it, but you're not fixing the whole thing. So it's going to be back in front of us again. And the amendments that I was bringing forward back in that November day were trying to help that. You can't set up a situation, but the government has set up a situation where you're dealing with those surrogacy, where you have a biological connection from one person but not from another. And the idea then and now, although I maintain it has to be available to both same-sex and heterosexual couples, and the government maintains it doesn't. But you have to, if you're going to say, okay, we recognize a birth mother and as being biologically important in this combination, and then the other person we're going to presume is the father, and we're going to make it through these changes possible for them to just be assigned that father role and not have to go through court and literally apply through the courts to be designated as the father. Good, that's exactly what you should have done, and I tried to make you do back in November of 2003. The problem with this is that you're not making that applicable to same-sex couples, and you have to, because you cannot distinguish that stuff. And the law has said that. We have married couples that are both, both orientations in this province, and you cannot say it's okay for these ones but not for these ones, because the law recognizes both of them. So it is discrimination, and this is now making it institutional discrimination against a group of people who by law are perfectly entitled to be what they are and should be able to have the same rights and responsibilities and privileges. So there's things in here like at one point it talks about a child can have a maximum of 2 parents. Well, interesting way of dealing with a legal argument, but the fact of the matter is you can easily have more than 2 parents. And in the case of, as I've said, same-sex parents, you're going to have to deal with the fact that you've got more than 2 parents here. But once again, the government refuses to recognize that. And again, you may not like it, and I understand that. I know that lots of people are not comfortable with this concept and don't want to see it and don't want to see it for anybody else. I understand that. You still, as legislators, have to write the right law, and this is not what's happening here. We're writing bad law. We're writing challengeable law. We're writing law that can be brought before the courts, and we will lose. And guess what? The taxpayers are going to pay for this, too. So how responsible? I maintain it's not responsible for us to knowingly pass bad law that can and will be challenged in the courts, and that we're forcing our taxpayers to have to pay the bill for somebody being intransigent in the government's philosophy. You may not like it, but it is the law. So I've talked a little bit about that concept of the best interests of the child, and I'll come back to that as we get into Committee of the Whole.